In the last few weeks, Waqf Amendment Bill of 2025 has been the center of heated debates around the country. Several people, several quarters are in support of this particular bill and several quarters are against it. Many term it as anti-Muslim and several quarters they term it as pro-Muslim or for the benefit of Muslim community of India.
Minorities कानून को स्वीकार नहीं करेगी। क्या धमकाना चाहते हो भाई? संसद का कानून है, सबको स्वीकार करना पड़ेगा। मैं गांधी की तरह इस कानून को फाड़ता हूं। ये अनकॉन्स्टिट्यूशनल है सर। इस देश में झगड़े पैदा करने का काम बीजेपी करना चाहती है।
जिस संविधान ने न्याय के रास्ते खोले, उन्हीं रास्तों को वक्फ कानून ने संकुचित कर दिया है। कर्नाटका में किसानों की जमीन पर दावा, कई राज्यों में गांव के गांव हजारों हेक्टेयर जमीन अब एनओसी कानूनी उलझनों में फंसी पड़ी।
Now, what this Waqf Amendment Bill is all about? Now, it has already been passed by the Parliament of India and President has given an assent to the bill.
President Draupadi Murmu has given her assent to the contentious Waqf Amendment Bill, which was passed by the Parliament on April 4th.
Which is why Waqf Amendment Bill is no longer a bill, it has now become an act. So what this act is all about, what are the significant provisions of this particular act, and the center of the debate, whether this Waqf Amendment Act of 2025, it's a property issue, or it's an issue of religion. We'll be discussing about this in this particular session and also comprehensive coverage of all the provisions of this particular act we'll be doing today. Hello, my name is Preetpal Singh and you're watching Perspective. Now let us very simply start by understanding the meaning of this term Waqf. Because it has taken over the headlines of the entire country, we need to understand first what does this term Waqf means. Now, Waqf is an Arabic word drawn from waqfa, literally means tying up. So, in Islamic tradition, when a person donates or ties up his or her assets, which can be tangible or intangible, that is movable or immovable assets, for the purpose of charity, is called as Waqf. And one more integral part for Waqf is that Waqf is irrevocable. That means once it is donated, it can't be taken back. It can't be claimed back, it can't be sold, it can't be rented or used in any way by the original user in any which way. Now, according to the Islamic history, the tradition of Waqf started when a Jewish man, Mukharik, wrote in his will 7 orchards would be donated to Prophet Muhammad. So the 7 orchards in Medina of this person would be donated to Prophet Muhammad, and after Mukharik passed away, Prophet Muhammad donated these orchards as charity. And that is where the tradition of Waqf began in the world, according to Islamic history. Now, according to the stated history, Waqf is made in the name of Allah, with a stated beneficiary or a purpose. For example, a person can donate his or her land for either a mosque or for a madrasa, for an educational institute, for a graveyard, for a qabristan, or for any sort of stuff. They can state that for what purpose they are donating this piece of land. Now, if we have to trace back the tradition of Waqf in India, it can be traced back to Delhi Sultanate. Now, in Delhi Sultanate, Sultan Muizuddin Sam Ghaur dedicated his 2 villages to Multan's Jama Masjid and appointed Sheikhul Islam as its administrator. Now, as the Delhi Sultanate and the subsequent Islamic dynasties, they flourished in India, the number of Waqf properties in India grew. Now, during the British time as well, a lot of controversies were surrounding the Waqf properties during the Britishers as well, because much of the Britishers were against this Waqf principle in whole, in entirety. But after we got independent, in 1954, Parliament of India passed Waqf Act of 1954. It was basically introduced to regulate and manage Waqf properties across India. It established the Central Waqf Council of India, which was established in 1964 as a statutory body to oversee the work under various state Waqf boards, which were established under the provision of Section 9, Subsection 1 of the Waqf Act of 1954. But there were several discrepancies in this particular act. And over the years, we saw several lacunas and challenges in implementation and the overall governance of Waqf properties in India, which is why in the year 1995, another Waqf Act was passed. Now, this was introduced to strengthen the management and regulation of Waqf properties, religious endowments in India. Now, this particular act, it mandated the establishment of Waqf boards at state level. So every state would have its own separate Waqf board, and that Waqf board will oversee the Waqf properties in that particular state. It also outlines the rules and responsibilities of the Waqf councils, the state Waqf boards, and also a chief executive officer alongside the duties of a mutawalli, that is a caretaker of Waqf properties. The person is known as mutawalli. Also alongside that, in this 1995 Act, there is also a provision of Waqf Tribunal. So it also defines the authorities and the limitations of a Waqf Tribunal in our country. And also, these Waqf Tribunals, they were given the powers of civil code under the Code of Civil Procedure 1908. And additionally, it was decided that the decision taken by this Waqf Tribunal would be binding and final. And no civil court is permitted to entertain any lawsuits or legal disputes related to matters under the tribunal's purview. Now, after the passing of this Waqf Act of 1995, still there were several irregularities which existed in the implementation of this particular act and in the way the Waqf properties were managed in India, which is why in the year 2013, we amended the act even further and Waqf Amendment Act of 2013 was passed. And even after that, several discrepancies still remained, which is why the current government last year brought Waqf Amendment Bill again. But that amendment bill, because of several controversies, it was sent to a joint parliamentary committee for its recommendations and for amendments which the committee would prefer and amendments which this committee would recommend. So the Joint Parliamentary Committee under the chairmanship of Jagdambika Pal submitted its report on February 13th, 2025. And 6 days after this report was taken forward by the cabinet and also the approval was given to this particular report. And after this, a new bill was tabled in the parliament in April of 2025, which is why the previous one, the 2024 bill, was repealed and a new bill of 2025 was put forward in the parliament. In Lok Sabha, a heated debate happened during the midnight as well. 12-13 hour long debate happened. Similar case was seen in Rajya Sabha as well. But of course, in both the houses of the parliament, this bill was passed and eventually President signed the bill and it converted into an act. And it has already come into force at the time while I'm recording this particular video. Also, alongside this, several opposition member of parliaments and several different other civilians as well, they have put a lawsuit in the Honorable Supreme Court of India challenging the constitutional status of this particular act. So now let us discuss the prominent and significant features of the Waqf Amendment Act of 2025. Now we'll be looking at 6 pillars through which this act can be scrutinized and analyzed completely. And all these pillars will talk about what happened before and what will happen after the passage of this Act of 2025. So let's start with the first pillar. Now the first pillar is in relation to Waqf by user doctrine. Now this is a very important doctrine. According to Islamic traditions, it recognizes the properties as a religious or charitable endowments based on its uninterrupted communal use. Please understand it very carefully. If a property is used by the community in an uninterrupted way, for example in a piece of land, there is a person who builds a mosque. And if people are coming to that piece of land and worshipping in the mosque, overall, after a period of time, that land in itself will be converted into a Waqf property even when the person has not explicitly given that land to the Waqf. So even in absence of formal documentation, where the person gives the land for Waqf, even with absence of that, just because that property is being used by the community, so because of the uninterrupted communal use of the property, it will automatically be considered as a Waqf property, as a religious or a charitable endowment. So basically their Waqf status will be legitimized through continuous public usage over the generations, even when formally there is no written agreement that this property belongs to Waqf. That is what used to happen. But according to this Amendment Act of 2025, this Waqf by user doctrine has been removed. Now, it has not been removed for the existing properties which are there. So according to the Waqf Amendment Act, all the Waqf by user properties registered before the Act's enactment will still remain and retain their status. But any other property further will not be a Waqf by user, even if it is utilized by community for communal purposes. If it is utilized for a longer period of time, it does not automatically become Waqf, which used to happen earlier. So this provision has been removed under the Waqf Amendment Act of 2025. That is the first pillar. The second pillar is inclusion of non-Muslims in the Waqf institutions. Now it mandates that the Central Waqf Council and the state Waqf boards should have minimum 2 non-Muslim members. And other than that, the requirement that the chief executive officer should be a Muslim, that requirement has been removed. So which brings more inclusivity in the Waqf handling and in the Waqf management in the country. Now one more change is in relation to the Waqf Tribunal. So Waqf Tribunal has been revised from a 2-member body to a 3-member body now. And each tribunal now will include a district judge, a joint secretary level officer of the state government, and also an expert in Muslim law and jurisprudence. So these 3 members will be part of the Waqf Tribunal, and it also clarifies that the tribunal constituted before the enactment of this particular act will continue to function until the expiry of their tenure of the chairperson and the member expires. Now these are the two pillars. Third pillar is in relation to increasing government oversight in the Waqf property surveys. Now in this particular case, an officer to the level of district collector, DC, an officer above the ranks of district collector, will conduct the survey in case of disputed properties, particularly where the government ownership is disputed. Survey would be conducted by a district collector or the officer above that particular level. And also the act says that the government official who will be conducting the survey will be the final authority to determine that the land, disputed land, does it belong to Waqf or does it belong to the government. Earlier it was the tribunal who was deciding, Waqf tribunal, whose word was the final, but now it is the government's officer whose word would be the final. And it would be locally done by the district collector of that particular area. And it also bars the classification of any property as a Waqf property unless the government officer of that particular area submits a final report to the government. Until that is done, a property cannot be listed as a Waqf property under this particular act. And yes, if the property is belonging to the government, if the officer says that this property belongs to the government, then they must update the revenue records and report to the state government that this property is no longer belonging to the Waqf and it belongs to the government. Also, the fourth pillar, the most important pillar of this particular act, is the repeal of Section 107 of the Waqf Act of 1995. Now, this means that the Limitation Act of 1963 would now be applicable on Waqf properties. But on the basis of the Waqf Act of 1995, it rendered that the Limitation Act of 1963 would not be applicable to the Waqf properties. But this has been reversed in the Waqf Amendment Act of 2025. And now the current status is that the Limitation Act of 1963 would be applicable in Waqf properties. But what is this Limitation Act? So Limitation Act of 1963 basically talks about adverse possession. And it says that any person who's in possession of a private land for more than 12 years or a government land for more than 30 years automatically becomes the owner. Now this act is now applicable for the Waqf properties as well, which will reduce the number of litigations to a very great extent. Now several opposition leaders have said that including this Limitation Act of 1963 for the Waqf properties as well would mean that any person who's occupying Waqf property for more than 12 years at a stretch would automatically become the owner. It would make these properties prone for individuals to be taken. Now, but Limitation Act is applicable for the entire country. It should be applicable for the Waqf properties as well. That is what the government contends. So this is the fourth important pillar. Now, fifth important pillar, which is again very important, is in relation to judicial review. Now, earlier there was finality of Waqf tribunal decisions in relation to all the matters related to Waqf properties. Waqf tribunal was the highest authority, and the matters in relation to the Waqf tribunal, the decision taken by the Waqf tribunal would be final, would be binding, and it could not be questioned in any higher authority court in the Indian territory. This is what the 1995 Act said. But now, the aggrieved parties, they are permitted to appeal directly to the concerned High Court within the first 90 days of the order issued by the tribunals. So after receiving the order of the tribunal, in the first 90 days, you can appeal that order in the High Court, respective High Court. And it has been purposely included in order to increase judicial oversight in the decisions taken under Waqf Act of 2025. And the last but again very important pillar is in relation to inheritance rights and tribal lands. So, in the case of Waqf properties, women and children would be adequately given inheritance right first before giving that piece of land to the Waqf. So this Amendment Act ensures that women and children, they receive rightful inheritance before any property is declared as Waqf by the state Waqf boards. So this particular Amendment Act explicitly prohibits establishment of Waqf on lands falling under the purview of Schedule 5 and Schedule 6 of our Indian Constitution to safeguard the tribal rights and tribal communities. Which is why this becomes the sixth pillar. And after understanding all these six pillars, we'll be able to understand what have been the measures initiated in this Waqf Amendment Act of 2025. Now, one common misconception which many people have is that all the Islamic countries in the world are having Waqf properties. But it's not true. Not all the Islamic countries have Waqf properties. For example, countries like Turkey, Libya, Egypt, Sudan, Lebanon, Syria, Jordan, Tunisia, Iraq, they lack Waqfs. In contrast, India is having huge parcels of land under Waqf boards. But if we talk about India, India's Waqf board, it oversees around 8.7 lakh properties under the Waqf of India. Also, it is around 9.4 lakh acres of land, which is estimated to be around 1.2 lakh crore worth of rupees. which is humongous. And one more important fact is that Waqf board in India is the third largest landowner after Armed Forces, who's the first largest, and second largest is Indian Railways. After that, Waqf Board of India is the third largest landowner in the country. Now, since we have understood the salient features and we have also understood what are the key provisions of this particular Amendment Act, let us delve into this question that the Waqf Amendment Act of this issue of Waqf, is it a religious issue or is it a property related issue? See, Waqf as a concept emanated as a religious issue from Islamic traditions, from traditions of Islam. But over a period of time, because it involved donation of properties or terming properties as Waqf in the name of God, property issue also got attached to it. And now if we see in the current times, it is more of a property related issue because it relates to transfer of property and land, which is why it can be seen as a religious issue as well, but more of it is in relation to property, which is why terming it as a property issue is also not totally wrong. And if we talk specifically about this Amendment Act of 2025, according to several experts, it has tried to bring transparency, it has tried to build accountability of the Waqf boards, it has streamlined administration to an extent, it has also improved the protection of properties, the rights of people as well, the right of women, the right of children, inclusion of other groups, other communities into the Waqf board as well. Inclusivity and diversity, it has tried to cater to and improve and also address certain historical issues which have been going wrong, and to address them and to remedify them in order to ensure equitable and just distribution of resources in the country. Now, definitely there are criticisms to it. Several sides, they criticize that it is infringing on the religious rights of Muslims.
इस तरमीमी कानून का मकसद वक्फ के इदारे को कमजोर करना और उसे बेअसर करना है.
It is one criticism which is being argued in the court as well. Also, several criticism in relation to enhancing government control in a religious matter. That is also several quarters are alleging for that also.
ऑल इंडिया मुस्लिम पर्सनल लॉ बोर्ड की जानिब से वक्फ अमेंडमेंट बिल 2025 के खिलाफ एक प्रोटेस्ट मीटिंग, पब्लिक मीटिंग रखी जा रही है.
Also, one more big issue which people are highlighting is lack of community consultation, which the government says that they have considerably done, but several leaders of the community, they are saying that lack of community consultation could be seen while the passing of this particular act was in place. Also, several sides have raised their concerns in relation to potential for enhanced and increased disputes and creating disharmony in the society in relation to communal tensions. These reservations and these apprehensions has been raised by several quarters, which are duly noted. Now, my purpose over here is to just state facts in front of you, that what this Waqf Amendment Bill or Waqf Amendment Act of 2025 talked about and what it did not talk about, and what are the salient features as compared to the previous act and what has been the changes made. Now, you are the judge. You decide with your own practical sense, with your own practical and rational mind, that whether the changes done in this particular act, are they legitimate, are they illegitimate, are they according to the provisions of the Constitution or not. It is for you to decide. I have stated all the facts in front of you. Do let me know what are your views in a civil way in the comment section. I'll be very happy to read your comments. All the very best and have a nice day. Thank you.